So I think it's all very well having these findings by the court in terms of how the investment advisors should promote particular financial products. But there's going to be some sweeping changes in Hong Kong as of June 2017. Now, I say that because the SFC is introducing a mandatory suitability clause in the bank's client agreements. Now, this is important for a number of reasons, but essentially, if a bank is recommending or soliciting a financial product, it must ensure that it's reasonably suitable for the client. Now, in determining whether or not a particular product is reasonably suitable for the client, the bank has to take into account the financial situation of the client, the investment experience of the client, and his investment objectives. So, from a legal perspective, it's also very important because this new clause is actually going to impose a legal obligation on the banks and financial institutions. They will only be able to recommend or solicit the sale of a financial product that is reasonably suitable for the client. So, if it turns out that a bank or financial institution has actually recommended a financial product that turns out to be unsuitable, the client therefore potentially has a contractual claim in damages which it can pursue in the courts against the bank, and that's something that wasn't there before. Although that clause that I've just mentioned, the suitability clause, doesn't come into effect until June 2017, it doesn't mean that the banks and financial institutions can sit back and wait for that to happen. The SFC has already issued a statement that it expects the banks to review their current and future client agreements to make sure that they're compliant with this clause. So the banks can't sit back, they have to review their current client agreements. It will be a lot of work, I'm sure, for the compliance departments, but it's something that they have to do now, and they have to be ready so that these client agreements are all compliant in June 2017.